Hello, everyone. Welcome to this new webinar. We're here with attorney Cynthia Milian from Powers Law Group. She is our senior associate. She has been, well, you can move to the next slide, please. She has been licensed since 2018. She has advice on a lot of immigration consequences of criminal charges. She is fluent in Spanish also. And well, Cynthia, the word is yours.
Thank you, Maria. So we're going to talk today about defending your case in immigration court while you're detained, what you need to know. There's been a lot of changes that have happened in the detained court setting. So we believe that this is a timely uh, discussion for us to have right now. So the basics and things that you should know about immigration detention. Um, Immigration detention is civil, it's not criminal, but it does limit the freedom and it complicates court defense. Especially now, we're going to talk about a certain case that's basically forcing or causing a lot of people to be subject to mandatory detention. So, in immigration court, also handled under the Executive Office of Immigration Review, which is overseen by the Department of Justice, the immigration judge and not the juries are the ones that decide cases. And the government's attorneys represent the Department of Homeland Security, while detained individuals, they have to defend themselves. They don't have a right to an attorney. So if they want an attorney, they can either get one privately, hire one, or if there's nonprofits that represent detained individuals, then that is another way for them to detain themselves. So how does this happen, right? It is usually after an individual is arrested by ICE, if there are raids, if they are encountered at the border. This is how the process essentially begins. Now, what we see in the detained setting is that cases move a lot faster. So this means that people have less time to prepare. And obviously, like if the person is detained, then they won't have the ability to get all the documents together and things like that. So we're going to talk towards the end on what you can do to prepare yourself in case you were to get detained. And how this works is that when an individual is detained, court is usually held in the detention center. So, for example, here in Houston, Texas, the local detention centers all have all the hearings that are done over video, over internet. So you won't appear in person for these hearings. They're all done over the platform that's called WebEx. And then whether or not you get a bond, it's going to be up to the discretion of the judge. So why do these detention happen? At first, at the beginning of the year, we thought that they were just targeting individuals that had maybe some criminal history, right? But now we're seeing that there's a lot more detentions that are targeted towards people that may look a certain way, or individuals that are here, right? We see people that are maybe subject to a raid, and because of that, they end up in detained and in removal proceedings. So sometimes they end up there if they're here without status, if they don't have any permanent documentation to prove that they are allowed to be here legally. It could be if they have any prior orders of removal when they run their fingerprints, and they can have that because we have seen that the local police has been working with ICE. If they have any outstanding warrants, criminal arrests or things of that nature, then that can trigger. If they've missed immigration court hearings that have resulted in orders of deportation, uh, those are ways in which a person can end up being in a detained. So what rights do you have while you're detained? Like we've talked about this multiple times. If you are detained, at that moment, you have the right to remain silent. You don't have to sign any documents. After you are detained, you have the right to speak to an attorney to talk about the next steps. Depending on all of the circumstances of your case, you may qualify for a bond before an immigration judge. You have the right to be treated properly while you're in detention centers, to medical care and interpreters. And so these are a lot of things that you have the right for, but unfortunately, a lot of the times we don't see them properly being carried out. But this is why it's important to have an attorney and to communicate with them throughout the entire process. So I talked about how it's been a lot more difficult for individuals to get a bond in this day and age, right? And the reason is because of this case that came out that's called Matter of Q Lee. This came out back in May 15, 2025, which has severely limited the number of individuals that can qualify for a bond. So basically, the argument is that individuals that were arrested shortly after they entered, that they would still be considered what is called arriving aliens. And because of that, they're not eligible for a bond. So, for example, in this case, it was for an individual that entered in 2022. She was arrested while she was 100 yards inside and eventually paroled. That parole was eventually revoked in 2024 and she was redetained. So then, whenever she went to request the bond, not only did the judge, but the board also denied. Um, and, the judge was basically saying that they had no jurisdiction. So what happens? Usually, if anyone that crosses the border, and if you are arrested shortly after, or, at some point later, you are going to be subject to this, it's called matter of Q lien. So if you were arrested and then released, you can still be subject to these. And this is for people that maybe were released on a humanitarian parole, 212D5 parole, or people that were detained and released and then placed in removal proceedings. So it's like I said, it's significantly impacted a lot of people's ability to request a bond. And then another thing that we've seen is that some have even taken it to the interpretation that people just entered, and that even if you didn't present yourself at the border, then you may not qualify for a bond. So a lot of judges interpret this in very different ways, and some of them just straight up say we don't have jurisdiction to see this bond or to adjudicate a bond. And so, you want to think about in that moment, what is the best strategy? Do you want to withdraw the bond and maybe pursue another means, or remain detained and fight your case, or see what is best for you in that moment? So do keep in mind the changes that have happened and how it has limited the number of people that can actually seek a bond in this day and age. And the other component is, if you do get a bond, what the department has been told is to basically oppose every bond. So if a judge grants a bond of $7,000, then the Department of Homeland Security will file an opposition to that. And basically, your client won't be allowed to post that bond, so they won't be allowed to get released. So we're also seeing that a lot of that, and it's not uniform. It's on a case by case basis, different judges doing different things. So certainly speak to an attorney if you're in this situation. So just some statistics about access to legal representation. Having a lawyer is the strongest predictor of success in detention cases. Without counsel, outcomes are much worse. So only about 17% of unrepresented detainees win their cases, and representation raises the success rates to over 50%. Um, if you have any detention, um, then you want to make sure that you contact a lawyer, right? Uh, and that you communicate with them and let them know, right? If you communicate with them, get a consultation to see what is the best thing that could work for you, and if it's viable. Okay. So bond hearings, like I said, they determine whether you are going to be released while your case is pending. So just because you're released under immigration, it doesn't necessarily mean that your case is over. It means that you are going to get released, but your case is going to remain pending. So it's going to be transferred from a detained to a non-detained docket. So like we mentioned, not everyone qualifies if you have criminal history. There's other things that to take into consideration, and the bond amounts can vary between 1,500 to 20,000. And these are real numbers. Yesterday, I was at an event where an attorney said that he's seen some judges grant like $43,000 bonds. So they vary depending on the history of the individual. And remember, the two things that you're trying to prove when you're fighting for a bond is that you are not going to be a flight risk nor a danger to the community. And the way that you prove this is you want to show the ties that you have to the community. So, for example, who is the family that you have in the US? How many years have you been here? Have you been gainfully employed? Have you been filing your taxes? And whether or not you're going to be a danger to the community, you want to look and see, okay, what were you charged for? What were you charged for in the sense of criminal convictions and and things of that nature. Was it something violent, non-violent? Have you rehabilitated? All of that helps in your bond request. Now, some people that have been detained and some that have been detained and have prior orders of removal are subject to something that is called, they can reinstate that order and they won't have an opportunity to go before an immigration judge and request that bond. They can just instate that order and remove them. But there is an option for individuals to maybe seek, if they have a credible fear interview, if they still have fear of returning, if there have been changes in circumstances. So you can request that. You can stop or remove if you can request and say, I need to see an officer. I have credible fear of returning. It won't get you back into certain type of proceedings that are needed, but it does allow you an opportunity to express to an asylum officer why you are or not, why you're afraid to return. And then based on what they rule or what they decide, then at that point, you will be considered whether or not you're going to be able to pursue withholding of removal or convention against torture or not, depending on the outcome of that interview. So if let's say you remain detained and you're not allowed to get out of a detained setting, then you're going to have two types of hearings: a master calendar hearing and a individual or merits hearing. A master calendar hearing is basically just where the judge is going to ask you basic questions. What is your name? How long have you been in the US? What is the form of relief that you are seeking? And in that time, the judge may ask you, how much time will you need for your final hearing? Who are going to be the witnesses? That's all discussed at the master calendar hearing. And the individual hearing, the hearing on the merits, is usually where you are going to present your case, where the judge is going to hear all of the testimony, the witnesses, the form of relief that you are seeking, and it's a full-on trial. So your attorney will question you, the government attorney will question you, the judge will question you, and then there's going to be an opportunity for redirects and things of that nature. So that is the final hearing that you are going to encounter. So what can you seek for relief if you are detained? There's always asylum, right? Asylum, withholding of removal, and convention against torture that are all together. Asylum, withholding, and convention are on the same application, but there are different standards that need to be met for each and different benefits that each grants you. There's also cancellation of removal. If you've been in the US for 10 years or more, and you have qualifying relatives that would suffer exceptionally and unusually extreme hardship, then you can demonstrate, then you can qualify for this. So qualifying relatives are either a parent or a spouse that's a permanent resident or a US citizen, or a child under 21 that's a permanent resident or US citizen. So you want to show, if they have medical issues, if they have cognitive issues, whatever it may be, you present that to the judge. You can also do an adjustment of status, apply for residency through a family-based petition, or in the alternative, if you don't qualify for any of these, you can seek voluntary departures so that you can avoid a removal order that will have consequences for you to try to re-enter at some point in the future. If, let's say, you lose your case in the detained court, you have an opportunity to appeal. That appeal must be done within 30 days of the judge issuing that order. Okay? Now, there are also federal appeals that you can do, but the difference between filing something with the board and filing something with federal appeals like district courts is that one will stop a deportation and the other will not. So that's very important to keep in mind, because you may be under the assumption that, after the appeal has gone with the board, if that's enough, that'll stop a deportation, but that's not how it works. If you've gone before the BIA and then go to the district court, that does not automatically stay or stop a deportation. There's a lot more that is happening in this day and age with individuals that are being held for longer, individuals that are being sent to different countries that they've never been to. So you want to consider things like maybe a habeas corpus, right? If you've been detained for longer than 6 months, or if there's threats that you can get sent to a country that you've never been to. If, for example, you're from El Salvador and they want to send you to Costa Rica, or to another country that you've never been to, there's possibilities and things, avenues to make legal arguments there. But it's important to talk to an attorney about what is your best appeal strategy. Okay. And if, let's say, you committed a crime and because of that crime, you are now in removal proceedings, and especially in a detained setting, just remember before you plead to anything, that an immigration conviction, sorry, a criminal conviction will always and can always have an impact on your immigration case, no matter how minor it is. So it's always important to talk to an attorney before you take, a plea on a case. And if you have pled on something and you weren't advised of those consequences, then you may have an avenue to try to reopen that case or get some sort of post-conviction relief under a case called Padilla versus Kentucky. When an individual hasn't been advised of the immigration consequences before they plead, then they can have maybe a means to try to get that conviction overturned. So and if you have already been convicted of something, just make sure that you have in your documents that you've gathered or that you gather just in case for a potential or an imminent detention, that you have certified dispositions for every time that you've been arrested, charged, or convicted, because the judge will usually like to see this in a bond request. How can your family and community support you? As I mentioned, nobody wants to be detained. Nobody wants to be detained. But there's ways that you can prepare yourself in case you are detained, especially in this day and age, because if you are detained, how are your family members going to find all of your documents that are important for you to have? So it's important to have all of your documents accessible in an area where maybe the birth certificates, proof that you've been in the US, your taxes and all of that is all in one place. Your family should know your A number. If you have an attorney right now, they should know who that immigration attorney is that's handling your case, so that way they can communicate with them to get copies of what has been filed or see if maybe they can take on your detained matters now. And it's important, to have your family's emotional support and strength, and help throughout the process so that they can be with you throughout the case and provide you that moral support throughout the process, because it's not easy, right? It's not easy being detained. So it's important. Immigration laws are very much changing on a daily basis, especially under, this administration. So being prepared is how you can protect yourself. So follow trusted news and immigrant advocacy updates. Educate your family on your rights if ICE comes to your door. Keep an emergency contact list with your lawyer, same with relatives, where to keep your children. Stay proactive. If you can get powers of attorney, do that for your children if you have minors, and don't wait for you to get detained before you start planning things. So knowledge is power in defending against deportation. So I'll turn it over now to Maria, and thank you for your time.
Thank you, Cynthia. And thank you for this great and insightful webinar. You can find us on our social media. We're on Facebook, X, Instagram, TikTok, also on Blue Sky, which is our new social media. And you can scan the QR code on the screen, and that way you can subscribe to our newsletter, which we are sending every 2 weeks. We're sending important information and important or breaking news. You can also find us on our website. It's www.rubypowerslaw.com. Now for August, we already saw what's navigating the perm labor certification process, also how to prepare for a credible fear interview, circumventing lawful pathways. And for next month, we're going to start seeing a little bit more about VAWA protections and other insightful webinars. All of these webinars are on our YouTube channel. You can find them there. And we hope to see you